In this recording, we're going to be looking at the laws involved with money. We'll start out by looking at banking, the bank systems and bank themselves, in terms of what duties and obligations they have. And then, more specifically, we're going to look at cheques as a form of negotiable instrument. Then, we're going to explore how debt operates in our system and really go through the mechanisms that are required to enforce debts, try and get money off people, or what's required if you owe money to another. And finally, we'll look as part of that enforcement mechanism at one of the options in terms of enforcing debts, and that's bankruptcy. Now, banking is a system that's been around for a long time, and for a long time in the British system, it was governed by the common law. And a banker at common law is simply a person, which is either a natural person or a corporate entity, who collects money from the general public and who honours cheques, in other words, instruments that are essentially demands of payment. Now, banking in Australia these days is very heavily regulated and falls under the Banking Act 1959. Now, banking has always been the exclusive domain of the federal government. It's not an area of law that's been governed by the states since the point of federation in 1901. And the key thing to note about banking is not everyone can do it, that you have to go through very, very rigorous and arduous series of steps in order to actually say that you are a bank operating a banking business in Australia. Banks themselves do have quite a rigid and rigorous series of duties that they owe, both to the customers, as I guess very direct stakeholders, but also to the wider society and to various government agencies, for example, ASIC or the tax office. But the duties, a combination of which are enshrined in statute, but some still flow from the common law, loosely to actually honour the demands for payments. Again, when a customer writes out a cheque, banks cannot just refuse to pay it out of their own whim. There has to be strong, structured reasons for not doing so. Banks are obliged to obey the customer's lawful directions. They're also obliged to receive deposits, and also when cheques are placed into the bank, to credit that particular person's bank account, the amount of those cheques. Banks have both a common law and statutory series of rules to do with secrecy. It's a very, very high bar. Banks are not simply allowed to give out their customers' information. And again, some of these things have been abrogated by statutes, for example, the anti-terrorism legislation. Banks have a duty to use reasonable care in terms of the advice given to customers. And we sort of think about this from other areas of law that we've looked at in this subject. For example, negligent misstatement, where you owe both a contractual duty, if there's a contractual duty to provide advice, and also under the general law of negligence, if poor advice is given. Banks also owe a duty, both a common law and a statute, to give notice before changing the nature of the relationship. And that's one of the reasons why you get a lot of paperwork from most banks in Australia advising of changes to do with interest rates, account structures, and the opening and closing of bank accounts. And finally, a role that I guess is diminished overall in terms of the fraction of what banks do in contemporary society. But banks still have this role of being custodians of documents and valuable goods, and so they can be the deposit takers of such things, and they do have duties, again, both in the common law and in statute, to take reasonable care of those items that are left in their custody. Banking customers, unlike the banks themselves, have far fewer duties, and often these duties, again, have been very carefully mapped out by statute. So Parliament has intervened to really go through and map out what it is that customers, particularly retail customers of the banks, are obliged to do. And so the first thing that, again, really flows from the common law is this idea of customers do need to take some aspect of care to do with forgeries and fraudulent activities in relating to their banking products. And while I'm thinking here largely of cheques and cheque law, which we'll discuss a little bit later, there's also an aspect of taking reasonable care to prevent unauthorized access of contemporary electronic accounts as well. Part of this, I guess, care that customers have to have in regards to cheques is, when writing them, to be clear and careful about how the customer drafts the particular cheque, how they go about writing it, how they fill in the information, so that there's no scope for fraud, misuse either by that customer or by third parties. And finally, there is an active or positive duty that customers have, that if they become actually aware of particular irregularities, and this can happen with things like overpayments, particularly massive ones, customers owe a duty to disclose these things to the banks themselves. One of the things that's popped up in the last sort of 30 or 40 years in terms of banks and their relationship with their customers is this idea that, look, banks are very powerful. They're very, very powerful entities in contemporary society. And being powerful entities, they have the power to influence. And in particular, they have this massive amount of power to influence the way that the contractual arrangements between bank and customers are outlined, how they're set up. And so in recent times, the banks have, partially voluntarily, agreed to map out and set an industry code of conduct. Now, this is not law as such. It's an industry code that banks essentially voluntarily place upon themselves to abide by these rules. And there's a whole series of these things in the Code of Banking Practice, the most recent one's from 2013, and that is that the banks will provide a lot more information about terms and conditions and interest rates and so on to their customers readily, and they'll actually actively take steps to ensure people have both have access to the information and have actually read it, particularly in terms of doing retail lending. They also have things to do with the disclosure of their fees and issues of timing. In terms of, essentially, there's in the code they have this idea that banks are supposed to process the information, process money as quickly as they can. It also maps out again the duty of confidentiality, which flows from the common law. They, in their code, state that they will actively try to show a good amount of care when people, again, particularly retail customers, come to the bank and are seeking a particular product. And an aspect of this is really trying to put a lot of time and effort into determining what the customer's precise needs are, rather than on selling them a particular banking product which doesn't meet their particular circumstances. Banks also must put in teams of staff to deal with difficulties. As a contemporary theme in a lot of areas of law, when we're dealing with individual citizens who can run into hardship. So banks are obliged to take hardship into account and have systems where they can come up with mechanisms to try and aid their customers, rather than trying to rely strictly on statutory rules and trying to boot them out as much as possible. Finally, there's steps to do with guarantees that banks will, must be very, very, very clear when offering services to a person where it's going to be guaranteed by a third party. And these guarantees, and again, a lot of times the banks themselves have run into difficulties, and cases have gone to the High Court. We will recall Amadio's case, for example, in the early 80s, where it was really negligent on the bank. And part of doing that is that the banks sort of have to really express these things very clearly to people who are going to take on these sorts of burdens. And also to make clear where there are situations to do with kickbacks, in other words, where the particular officer of the bank is going to receive some form of remuneration in some way for dealing or selling certain types of products. And finally, the banks are obliged under the Code of Conduct to provide procedures for dispute resolution. When things come up and the customer has difficulty with the banks, to try and avoid that immediate step of going to the ombudsman or going to through the court system, to have systems in place to try and resolve things before things get a little bit more heated. One of the features of banking that has been important throughout the history of banking, but in modern times has really taken a bit of a back seat in terms of our own experience with day-to-day transactions, is the use of checks. Now, checks, and here, just to be clear, I'm not referring to what we would call bank checks. Those are orders where you go into the bank and pay a sum of money in order for them to set aside a sum that can be transferred directly to another bank. That's a different, really fundamentally different kind of instrument. Here, thinking about the checks that an ordinary person could actually physically carry around and write out themselves. And essentially a check is an instruction. It's basically an instruction by a person telling another person, in this case being the bank, that they need to pay someone a certain sum of money. Checks and check law is governed by the Cheques Act, and again, checks themselves in this day and age are usually pro forma documents where the bank, as part of their terms and conditions, issues checks that are structured in a very, very particular way and style. It has all of the necessary information on it other than the amount and the person that things are going towards. Now, there's two types of these checks. We call them either order checks or bearer checks. And you may recall from your own experience in writing checks that there's usually there's two words on most pro forma checks that just say or bearer. And usually a person, when writing a check out, will cross that out. In that situation, this becomes an order check. So this is the most common type of check, and it's one of those things you may have recalled from for any of those that have had or used a checkbook, that one of the first rules they suggest is the first thing you do when writing a check out is cross those words or bearer out, because the key distinction and difference between order and bearer checks is that with an order check, the payee, in other words the person who is going to receive the benefit of the check, is identified. Now, with this type of check, you can actually transfer checks, both order and bearer checks. They can be transferred as an item of property. Now, the rules for doing this are, it can be a little bit complex and convoluted. I'm not going into them in too much depth, but the key thing to note here is that because both order or bearer checks are negotiable instruments, the check itself can be transferred to another person. With order checks, that requires a signature. And again, if the person that the check's addressed to is named, then in most circumstances that requires a person to cross that out and sign for that change or alteration. It also requires a delivery to the other party and clear demonstrated intention in order to transfer title to another. Now, a bearer check, however, doesn't have that requirement of signature. In other words, the title to these bearer checks can be transferred to another party simply by clearly demonstrating that you wish title to pass and delivering it to that other party. Finally, a thing to note here is that bearer checks can be converted into order checks, and again, I mentioned that those magic words, or bearer, if you simply cross those two things out, as one commonly does when writing a check out, that will convert a bearer check into an order check, this more restricted title where the payee must be identified. Now, there's three other things you can do with a check when you're writing it out that will change the way that the receiving banks, the bank that things are being paid into, are going to deal with that particular instrument. The first thing is the crossing. So if you put two parallel transverse lines, so two lines next to each other, from top to bottom of the check, The key thing to note there, that's known as crossing. All that does is tell the bank that money is to be where the check has been presented, that they aren't allowed to pay cash over the counter. They have to actually go and put the money into a bank account. That's the first of these, and again, that's Section 54 of the Cheques Act. You can also write the words "not negotiable" in between those two lines, and what that does is that it essentially restates the Nemo-Dat rule, and it means that while the check can be assigned from one person to another person, the person it's being assigned to can't get better title. In other words, if there's a situation where the check has been stolen, for example, then that defect won't be remedied, even if the instrument is passed or assigned from one person to another with consideration and in good faith. Finally, the words "account payee only" can be written on a check. These don't have any significance under the legislation. All they do is to basically put the collecting bank on notice that this particular check, they need to go through and just be rigorous about the various instruments, the various pieces of information that are on there, usually in terms of checking ID, to make sure that this particular check is actually kosher. In other words, it just instructs them to really pay attention to the information that's supplied. The next area I just want to talk briefly about is the use of credit cards, debit cards, and other electronic payment systems such as PayPal. And really the key thing to note about these systems is that fundamentally they're just governed by contract law. When a person asks for a credit card, for example, at American Express, that particular person is forming a contract with the Amex corporation or company, usually through one of the major banks in Australia. And when they purchase something, the person is making a contract with the merchant, and the merchant also has a contract as part of their them having the machine to take the American Express. Basically, there are three contracts that operate as a result. What that means is that the dispute mechanisms that are used between each of these three parties is governed by contract law. And so when things do pop up, as they do from time to time, these things can be taken as an action between any of those two against either of the other two. And it's important to note that there are additional regulations to do, for example, credit cards, because the issuing of credit is governed by some other areas of law as well. It's also important to note that there are tax implications, and so how things operate in regards to the collection of taxation for things like GST. These require a fair amount of regulatory oversight. But what you find in practice is that the credit card companies and the PayPals and similar systems, payment systems as well, are very large, and often the mechanisms they use for dispute resolution are dealt with internally, and often they're very favorable, particularly towards small retail clients and customers. One of the emerging challenges then is cryptocurrency. And without going too much into the technical aspects of this, but and I'm thinking particularly of blockchain, such as Bitcoin. One of the difficulties from a technical perspective is that an individual purchasing things using blockchain isn't very easily traced or traceable, and so the amounts can't easily be tracked. Now, some things have come from this, and again, the examples I've got here are really from tax law, because like a lot of areas of law where things are responding in terms of new technology, the ATO, the tax office, have get onto these things reasonably early, and they will issue statements about how certain types of technology operate within the framework of the existing law, often before Parliament's had a chance to catch up. Now, the key things to note about cryptocurrency, first is that it's not a currency. It doesn't count as a foreign currency in terms of, for tax purposes, it doesn't count as money. So the area of taxation law it falls under is barter. A person is swapping some amount of the Bitcoin or whatever similar blockchain currency, and they are swapping it for goods and services, or money in some situations. And so the key part here is that is operated as if these things were assets themselves. And so, for example, capital gains tax will apply in situations where a person purchases for the view of gaining from the acquisition of cryptocurrency. And the other thing to note there is that it's also trading stock. So if a person is purchasing Bitcoin or similar currency for the express purpose of reselling it, or in the ordinary course of business, then it's going to be deemed to be trading stock and fall under the relevant tax provisions in the New Income Tax Act, Section 70. One other really important thing to note that isn't mentioned here on the slides, and that's to do with onus reversal. And that while we look at these transactions as being untraceable, undetectable, and governments can't easily go through and access that information, what government agencies, and particularly the tax office, can do is just reverse the onus. And what that essentially means is that rather than them being unable to demonstrate that you've earned a particular sum of money through a series of transactions, they can flip it around and say, we deem that you have earned this much money. If you don't want to be whacked with this massive tax bill for what we deemed you to have done, you have to put all your cards on the table, essentially, and demonstrate through the transactions that you have done that you aren't liable for the amount that they've put forward. Now, and again, while this seems quite an onerous series of steps, it's important to note that a lot of spruikers have popped up in the last decade or so in terms of cryptocurrency, and it's really important to notice that the existing area of law that governs these types of transactions is more than capable of being operated and employed by some government agencies, particularly for the purpose of ensuring that you pay an appropriate amount of tax. Another thing to note about the various electronic payments organizations, again, I'm thinking Amex, Visa, PayPal, and so on, as well as the banks themselves, have come together to create, again, a voluntary code. So similar to the coding of banking conduct, the ePayments code is designed through this voluntary opt-in system to really set a minimum set of standards in terms of how consumers can deal and engage with electronic payments, either through cards or via the internet. And a lot of these things are actually quite similar to the banking code of conduct, really about making terms clear, unambiguous, demonstrating to them how the terms and conditions work, making it clear how a person can access the terms and conditions, as well as their own financial records, their receipts and such like. And also to set out systems to do with when things go wrong. So when transactions have been made which are unauthorized, or, as can happen from time to time, when money goes into the wrong account. So there are systems that these various electronic transaction entities have set up to really map things out between themselves, how these things are going to be catered for, and particularly in terms of the retail environment of consumers. The next area of law I want to talk about in this recording is to do with debt. And debt is simply an amount of money that's owed by one entity to another. Now, the mechanics of debt and how a person can go about resolving them, particularly in situations where a person doesn't pay, there have been a long-standing series of common law rules that go back thousands of years. really governing how the arrangement in terms of the debtor and creditor operate. And when a person owes you money, there's lots of ways you can go about really ensuring that you do get some form of payment from them. Now, some of these have to be done ahead of time. So the important thing to note here is that when a person enters into an arrangement with another, usually the borrowing of money, that there can be some form of security across property. Now, this property can be either to do with this particular transaction. For example, if you purchase a car, and while you get all the benefits of the car, driving it around, this, that, and the other thing, the amount that's owed to the vendor, usually the car selling entity, often that is secured against the vehicle itself. So if payment isn't made and a person falls behind under the terms of the contract, that entity can just essentially, as a self-help remedy, arrive, grab that item of property, take it away, and then sell it. And then again, they can still chase you for the difference if the amount that they sell it for is less. Or you can have situations where the debt is secured across the property, but if you fall behind, they can repossess it and you can walk away. Again, these things are governed by the particular contract itself. Similarly, debts can be secured across real property, in other words, mortgages. So if a person takes out a mortgage on either a personal or a commercial property and they fall behind, the bank will invariably reserve the right, if payments aren't made, to enter the property, seize it, and again, following a series of statutory powers that they're given, to sell that property. And again, the nature of the contractual arrangement will determine whether or not the person buying the property has the right to walk away. In other words, if the amount owing is less than the property's worth or what it can be sold for, and in that situation, the bank can't come to them and ask for the difference. Or in most circumstances, if the amount of the real property is less than the amount owing, then it can be sold. The bank exercises what's called its power of sale, and then can still come and seek the balance, the difference between those two things from the individual. Now, there's another type of security which happens with companies where the debt is secured against assets. Now, it can be secured much like with this bill of sale across a particular item of personal property, or it can be registered over a class of assets in that company, or even more broadly, floating across all assets of the company itself. And these things can be important when companies get liquidated, because there's a series of steps in terms of priority. Who receives payment first? And if there are charges across assets and a particular company has run itself into financial difficulty and is being liquidated, the entities that have the charges, in other words, the person who's lent this company money, then they've had difficulty repaying this debt, they can come in, grab either that asset or that class of assets, take those away, and then sell those. Another area to do with assets is something we've talked about in earlier recordings, known as a possessory lien. So say, for example, you go to get your car repaired at the car garage, and you go and send it in. It's going to cost $1,000. Now, they have the right to hold on to your car until you return and pay for it. Now, at common law anyway, that particular vendor, that's the repairer of the vehicles in that situation, can't sell your car. They just have this possessory lien to retain possession until the services related to that, and that situation, that vehicle, have been paid for in full. Another way that a person who enters into a debt arrangement can be assured that the amount of money is going to be repaid can come through guarantees. In other words, a third party can state that they give assurance to the person lending the money that they will step in and pay if the person the money is being lent to defaults. And again, there's guarantees which must always be in writing in a system, are things that can happen, for example, with large sales of real property. Can also happen with corporate entities as well. And it can be a little bit more complex, where rather than a formal guarantee, what's called a letter of assurance is given in situations where you've got a group of companies. They don't necessarily have the same strictness that a guarantee has as a contractual instrument. And finally, a vendor who sells goods to a company or an individual can elect contractually to retain title to those goods. Now, this is known as Ramalpa clause, after the Case Aluminium Industries and Ramalpa Aluminium, where this was really mapped out by the British courts. And these things are common in situations where you're not too sure about the party that you're selling your goods to, and they're supposed to pay at a later date. Now, the flip side of this, and you may recall from the sale of goods, stuff we did earlier in the subject, to do with the passage of title. Title under the Sale of Goods Act will pass where the parties intend it to. And in situations where you don't want the people you're selling it to be able to return the goods to you, then you may insist on a money payment. And they won't have this right to send the goods back. However, in other situations where you're not sure that you're actually going to get payment, you can include in the contract, hey, title doesn't pass until these have actually been paid in full. So you retain the right to arrive if the goods aren't paid for, grab them and take them away. And again, which of these is better for the vendor can really depend on the circumstances. And it's important to note in situations where you're looking at contractual arrangements where title passing is going to sit. Now, the next area of law to look at is to do with enforcement. And it's important to note in situations where one party has a debt to another one and that amount is known. That's known as a liquidated debt. And a liquidated debt dispute will often operate different in terms of the courts than one where there is some doubt or dispute about the amount which is owed. So, for example, QCAT can actually hear liquidated debt disputes up to $25,000. But if, in fact, the dispute is not about a debt, in other words, there's some sort of facts, and that requires there to be some form of trial, then it can't, unless it falls under one of the other areas, residential tenancy or consumer dispute. I think a couple of other things you need to know about liquidated debts is that these can usually arise through some form of contract, and the contract can stipulate what the amount is. And in situations where money's been lent, that can be reasonably calculated, and that can form a liquidated debt dispute. It can also arise in situations where there's been a breach of contract, and there's a pre-estimated damages clause in that contract. And a couple of things to note about these debts, in that if it can be clearly demonstrated that a debt is owed and the amount is clear, and this liquidated debt rules apply, these, in most circumstances, can actually be on-sold. So the debts, for example, that a person might owe, say, a utilities company, are quite commonly on-sold to debt collection agencies who pay a certain fraction of what the debt is worth, and then they bear the risk, and they go through the steps of trying to enforce that through the courts if need be. A key component of contemporary business, particularly to do with enforcing of debts that are owed by other parties, is the system of sending letters of demand to people, like demanding things to be paid with a certain length of time and giving them some scope to actually pay prior to commencing action. But it's also important to note that actually sending formal letters offering to settle a particular dispute for a certain amount can actually impact the final costs award that the court will give the winner if the matter actually does go to court. And so the key thing to note here, first of all, when issuing a letter of demand, often in that situation, you're happy for that information to be used by the court as evidence. And so a letter of demand will simply state the name and address of both creditor and debtor, the transaction and the reason why you're owed this particular sum of money, the amount of money, and time to pay. It has to be a reasonable amount. And again, traditionally the reasonable length is 14 days after it's served on the other party. Now, the key thing to note there is that if you want this letter, if you are the debtor, to actually be put before the court. However, if at some stage later, either the other party or yourself want to go through and settle, in particular if they're willing to settle for a lower amount, then this can actually be done. And letters or offers to settle amounts can be done without that particular letter or offer being able to be adduced by the court. And the reason why they do that is that the courts basically don't want people going to court. It's time-consuming and expensive, stressful. And really, there's the burden of taxpayer dollars too, who are actually having to supply the various judicial offices and the locations and such like. So the courts and Parliament, the government, are very, very keen for people to try and resolve their disputes ahead of time. And the idea of being able to send an offer without prejudice is a very important component. And so that these particular letters that you can send to the other party offering to settle have to clearly have the words at the top, without prejudice, save as to costs. All that means is that, look, we're not going to neither going to confirm or deny the particular conduct, and look, this matter may go to trial, but to try and avoid whatever reason it going to trial, we're happy to pay this sum of money, or willing to accept this sum of money, in order for this matter to just dissolve, to go away. And these are known as call-to-bank offers. They come from call-to-bank, an English case from about 40 years ago. And it's a really important part of the negotiating process to really know the system, in particular when you receive one of these letters, what those words at the top actually mean. Now, if you go to trial and the matter needs to go, and it's a dispute between parties that requires a judge to determine, the judge is going to determine one way or the other. There's going to be a winner and a loser. And the default rule with costs, and these are legal costs incurred in the process of getting there, is that costs go with the cause. In other words, the winner at trial gets the other side to pay their cost. But by default, they're not going to pay all the costs. They're going to pay a small amount. When I say small, not insignificant amount, but usually a lesser amount than what the party has incurred in terms of legal expenses, either the plaintiff or the defendant. And this is known as the standard basis, and it's set by regulations where they fix a certain amount, for example, per hour for a barrister, per hour for a solicitor, and per photocopy page, and so on. And the key thing to note here is that while costs generally go with the cause, they are on what's called this standard basis, but offers that are sent to the other party following the appropriate rules and given appropriate length of time for them to consider them can impact or change how those costs are awarded. And so the important thing to note is if the plaintiff, the person bringing the action, has made an offer to settle for a certain amount, and that's been refused by the defendant, and then they've gone to trial and they've won actually more, look, the defendant's been a little bit silly here and wasted everyone's time. And so the rules that are set out in the UCPR, the Uniform Civil Procedure Rules, actually state that, look, if an offer has been made and you essentially unreasonably refused that offer, you had to pay more afterwards anyway. So instead of having to pay standard costs, you actually have to pay indemnity costs. You actually have to pay all of the money that the other side has incurred in terms of legal expense, and that can be significantly more. Now, another situation where this can change is if you are the defendant for a matter and you still lose, but you made an offer to the plaintiff to settle. All right, and the plaintiff still won. So again, usually the costs go with the cause, and the plaintiff would get your defendant would have to pay plaintiff's costs. But if the defendant's made an offer, all right, and the offer they made was actually more than what the plaintiff actually got, then the defendant still has to pay the plaintiff's costs on the standard basis up to the point where the offer is made. But then the plaintiff pays the defendant's costs from that point onwards, from the day that particular offer was served to them. An important thing to note about suing somebody, in other words, bringing an action to the court, is that you don't have an unlimited time to do this. The standard rule for breaches of contract and tort, and in fact for most areas, is that you need to go within 6 years to the courts to file your action. Now, note that the 6 years starts, in other words, the clock is on from the moment when the right to sue, the bare right, will arise. And so for contract, for example, that is at the point of breach. For tort, however, the point in time is the point in time where you get, or you can satisfy all three elements of the tort of negligence. And so that requires it, logically, to be after you've actually suffered some form of harm. And so it's important to note that for actions in situations where the duties in contract and the duties in tort coexist, that the time limitation can actually be different for the two of them. It's also important to note that things involving personal injury, be they in contract or in tort or any other stat duty, they have a tighter time frame. You've only got 3 years to apply to the court for if personal injury is involved in those situations. Also note that defamation is a specialized tort. It has a very narrow time frame. You've only got 1 year from the point in time that the matter is published. Now, if you have gone to court and you have got a judgment in your favor, there is also a time limit that you have in order to actually have that judgment enforced. So if you drag your heels for a very long time, they will also time out as well. So you've got 12 years from the point in time when the order was actually granted. Okay, so just assuming that the parties haven't managed to settle and the thing needs to go to trial. So it goes to trial, one side's going to win, one side's going to lose. And so that side that does win is awarded a judgment. That's an order of the court demanding, usually, that the other side pay a certain sum of money by a certain date. And again, we've talked about other forms of remedies that a person can seek from the court, specific performance and injunctions and so on. But thinking here just in terms of damages, a dollar award, that is an order of the court and has the power of the court. So if a person doesn't pay it within the time specified in the order, then the creditor in this situation, the person who holds the judgment, can try to enforce that. And so the first step that they have is what's called an enforcement hearing. And that is a hearing, usually in front of a magistrate or the registrar, where the other party is required to turn up, fill in a form that says what assets they have and what liabilities they have and what income streams they have. And if they don't turn up to the hearing, the court again can, if the plaintiff, the winner of the matter has sufficient information, they can hand that up as evidence, and they can just proceed to the next enforcement step, which is the issuing of warrants. Or they can adjourn it and make the person turn up. And if they don't turn up, they're in contempt of court. And the courts can take alternate steps at that point as well. And so the key part here is that if this hearing is proceeded or it hasn't been complied with properly, the creditor can ask the court to provide an enforcement warrant. And that's basically a warrant for them, and in situations where there might be a bit of danger, for the police to arrive as well, to enter the other person's property, seize property, to sell it, and also for them to send letters to financial institutions and to employers to redirect earnings or other debts that are owed. And finally, last thing I just want to talk about is that, look, if the amount owed is more than $5,000 for an individual, the creditor can actually ask for the debtor, the person still owing the money, to be made bankrupt. This is known as a sequestration order. And it's not a step that you do lightly. It's in situations where the party has demonstrated a clear unwillingness or inability to pay, that you can really ask the court to declare them bankrupt so that their property passes into the hands of a trustee. And a key thing to note about bankruptcy, which lasts for a period of time, is that with a few exceptions, all of your stuff, you as the bankrupt, is now vested with the trustee. You don't own it anymore. There are some exceptions to do with motor vehicles, items or tools that you use for personal exertion, and some household items you're allowed as well. Also, property that's held on trust by the bankrupt for another is exempt from bankruptcy. It won't vest to the trustee. Certain superannuation funds, life things or life insurance policies, and certain types of long-term deposits won't form part of those pooled assets that go and get vested in the trustee as well. And the final thing to note is that bankruptcy, which usually lasts for 3 years, requires the bankrupt to do a series of steps and refrain from doing a series of other things, generally to do with large financial transactions. So they can't, they have to arrive to court, they have to fill in the statement of financial position, they have to give all of the records, documents to the trustee, essentially to transfer title to the trustee. They have to follow the directions of the trustee to attend and to actually answer questions. They have to surrender a passport, and in fact need to ask permission of the trustee before they can travel overseas. There has to be a meeting of creditors if there are more than one person that the bankrupt owes money to, and the trustee has to bring along all the documents to that. They're not allowed to obtain credit. Bankrupts can't hold certain positions of office. They can't be MPs, for example, and they can't be solicitors. The bankrupt has to also give some personal information, telephone number and address. They're not allowed to just travel interstate without telling the trustee. And I guess the important part is that they're not allowed to deal with property. So the title to property is vested with the trustee. It no longer is owned by the bankrupt. The trustee is going to take care of those affairs and to try and pay out the creditors wherever possible. Bankruptcy lasts for 3 years, with the idea being that after the 3 years you can start again. But note that there are some aspects where you have to declare when filling in certain positions, and again to become a solicitor or an MP, that you have been a bankrupt at some stage previous in your life. And finally, bankrupts throughout the course of bankruptcy can't be company directors without seeking leave of the court. So not just the trustee, they actually have to go and ask the court if they are allowed to be involved in such things. And fundamentally, this is all about trying to balance the rights of creditors to be able to get as much as they possibly can from that person, but also really to encourage people to take normal, ordinary business risks. And from time to time, things will go wrong, and we accept and respect this. And so the systems of bankruptcy, and certainly the stigma of bankruptcy over time, has become less really pervasive. It's less of a thing, and we accept that again, things can go wrong for people in their lives and their financial affairs. And as such, the rules of bankruptcy are really there to allay that. So I hope this recording has been useful, and that those listening have picked up a few things to do with banking, debt, enforcement, and bankruptcy. In this recording, I'm going to look at the area of law known as tort. Tort is the mechanism in civil law for making people responsible for wrongful actions.